right, everybody, welcome back to the Learning Out Loud podcast. I'm your host, Dustin William. I have my co-host with me, Whitestone.
It is undeniable that a vast proportion of the actual doctrines and rules which make up the system of equity are necessarily inferences from or direct applications of some or more of these fundamental maxims.
The power is neutral. It's sitting in the quintessence until you invoke it. Behind using these things are good and holy and Christ-like.
I shall now attempt to show how the most important of these principia have been crystallized into the pithy form of maxims and have influenced and developed that grand system of truth known as equity jurisprudence.
All right, welcome everybody to the Learning Out Loud podcast. This is episode 2, where we are going to start getting into the maxims of equity. I am your host, Dustin William, the owner and producer at True Life Productions. You can visit truelifeproduction.com to see all of our content, such as All Aboard, where I get into history and the orphan trains in particular. Article 3, Articulations, where I pick a Supreme Court decision and I break it down to you fully. On my website, I have the most comprehensive breakdown of the slaughterhouse cases there is available on the internet, including all cited sources, some newspaper articles from the time that talk about some potential fraud in the case, all bunch of spicy stuff over there. Go ahead and check it out. And then from there, you can head to the Thought Crime Dojo, where you can watch my research unfold literally as it happens. There's tons of resources over there. Just the bookshelf and the law library will keep you busy for days. But that's enough with the business. Let's get down to why we are here today. Like I said, this is episode 2, and we are going to get into the maxims of equity. But before we do that, let's introduce the co-host, Whitestone. How's it going, man?
Oh, doing well. Looking forward to talking about in personam.
Yep. This is a big one, and yeah, I'm excited to actually get into the maxims now. It's cool going through the history and stuff of it all, but now we're really getting into the meat and potatoes of what equity is now. And we're gonna start with we're gonna go back to Mr. Tully's speech that we talked about last time. We read all the way up until when did we get to page 11 in the document. If you want to follow along, we're gonna go from page 11 to 17 today, and this is all gonna be about what Tully feels is the most important and fundamental maxim of equity jurisprudence. So, before I get into it, you got anything you wanna add before we start doing our reading today?
Well, I was going to say, I think he's right in considering this one probably the most important maxim, because equity, it's equity acts on the person's conscience. Mm-hmm. And you can't really do any of the other, talk about the other maxims of equity without having in personam jurisdiction.
Absolutely.
So, this really kind of is the foothold. And, we even see some of the writers talk about that equity is always used as a foothold to get in personam jurisdiction. And then they either proceed with equity or at law because they have the person. So this really is the crux of them.
Yeah, absolutely. And you hear that in personam, and that's a almost an at-law term today. When people hear in personam, they're going to think at law, but we're going to give you the other side of the story today. So, that's
all I got.
Okay, cool, man. Yeah, let's go ahead and get into it then. Like I said, we're on page 11 of the Murray F. Tully speech to the bar in 1903, the Illinois State Bar in 1903, which he was the president of at the time. So, number 1, Agere in personam. This is not only perhaps the first maxim enforced in the court of equity, but it may be not inaptly termed the germ of the equitable procedure and the father of equitable maxims. It was the first method of enforcing action in the interest of right and justice that caused jealousy on the part of the judges of the common law courts, and for a time produced confusion and greatly retarded progress in the equity court. The history of the long and bitter struggle between the law courts and the courts of equity is well known to all students of law and need not be here recounted. The struggle was whether the court of equity, by obtaining control of the conscience of the party, by getting jurisdiction over his person, should do justice between litigants in cases where the methods of the common law courts operate to produce injustice, or failed to do justice. By reason of their inflexible adherence to rigid quote-unquote precedents and form, Lord Kames, in his memoirs, in defining law and justice, says, quote, "Law from its very nature is mutable, susceptible of perpetual improvements, but justice, which is the object of law, is fixed, immutable, and certain. The good judge, like an able pilot, will use the former as his compass, but aware of its occasional error and variations, he will look to the latter as his polar star." I like that he uses the term polar star there too. A lot of meaning to that. I remember at a meeting of the Sunset Club, one at which the subject of discussion was, quote, "the delays of the law." The presiding officer, a talented gentleman but not a lawyer, thus defined the difference between law and equity. Now, when you go to law, you get the law as it is. When you go into equity, you get justice. I love that that he points out that was a non-lawyer too that said that. That's great.
It's very telling.
Yeah, because obviously we're non-lawyers. So
is he saying that really only non-lawyers could actually understand equity?
Well, he who comes at equity must come with clean hands. So
yeah,
it would be unjust to claim at this day that one can only get justice in a court of equity, but at the time, that court was struggling to get a foothold in the jurisprudence of England. So intolerable had become the failure of injustice in the law courts, and so great the actual injustice perpetuated in their administration of the law, that the remark of the Sunset Club official would have been very near the truth as applied to conditions then existing. The few writs then known, and all the machinery of the law was in the control of the law courts. So, yeah, that's a great little introduction to in Agere and Personam there, talking about how when they say in personam, they're not just saying in person. They're talking about because obviously person, there's a lot of baggage to that term right there. So it is distinguished by them stating that it acts on the conscience of the person, not just the person itself, not his property, but his conscience.
Yeah, because that was, if I'm not mistaken, one of the pitfalls of the common law is the common law could compel the property, but could not compel the owner to do anything about it.
Mm-hmm.
And so, they really had to have a way to get a hold of that person and force them, or compel performance.
Mm-hmm.
Otherwise, that was kind of the rigid form of the a part of the common law, is that they didn't have that. But on the other hand, if they're going to get you in person and get control over your person or over your conscience, they have to make sure that they're not going to abuse it, which is why I think equity has the sort of open door policy positive aspect to it, is because it has to be there if they're going to force you.
Yeah, absolutely. They can't act on your conscience and not have a conscience themselves, for sure. Yeah. Yeah, and like I just restating it here before, a talented gentleman, but not a lawyer. Thus define the difference between law and equity. Now when you go to law, you get the law as it is. When you go into equity, you get justice. And that's just, that's just a very eloquent way of restating what Whitestone just said. And that's, like I said, I gotta restate it, but a non-lawyer. So everybody out here talking about how, you're not a lawyer and blah blah blah, and you can't do trusts and this and stuff and that. Well, yeah, you're right. We can't represent a trust in court, but we can get into a court of equity. We can do that.
Yeah. And it's funny, they say well, you're not a lawyer, you can't do trust. It's like, well, what you're talking about is somebody having power of attorney in order to do that, which they usually associate with someone who is a jurist or an attorney or a lawyer. They don't realize that, nope, every single person, as long as they are competent of their own affairs, is attorney in fact of their own estate.
Exactly.
And so, and equity was not, it didn't come out of the mouths of the lawyers.
No, it came out of the conscience of the judges.
Yep. And he even refers to it right there at the end of that paragraph you read, the machinery of the law, which shows that it is a machine. And, you might get cycled through it, or you can go to equity and they can, not grind you to bits.
Yeah, have a little conscience thrown in there. Right. Yeah, for sure. All right.
All right. Well, is that all you got?
Yeah.
I can
pick up. We can move on. Yep.
All right. The court of equity was not originally a court of record, and therefore could bind the person only, and neither the state of the defendant's lands nor property of his goods and chattels. It proceeded upon petition and without any writ or formalities. The defendant, having been notified, appeared to hear the king's pleasure through the chancellor. The petition was at once disposed of in short order or degree, granting the relief prayed in whole or in part, dismissing the same for want of equity. As the nation progressed in population, in its industries, its commerce, and its civilization, and these new and expanded conditions raised new questions for the actions of the courts. The inadequacy of the rigid doctrines, rules, and methods of the common law became more and more manifest. When to these changed conditions was added the introductions of uses into the conveyances of the nation, the absolute necessity of a court which could compel the performance of the use or trust was admitted even by the law judges. The Court of Equity did not attempt to invent new writs in opposition to those of common law, nor to put itself in defiance of the action of the law courts, nor did it set aside a judgment or attempt to act directly upon the writs or proceedings of the law courts, notwithstanding the law judges contended that the chancellor invented quote-unquote conscience as an element to be considered in a case for the purpose of founding a mode of proceedings in opposition to the law courts. Mm-hmm. So it seems like what he's saying there is equity is actually coming into law with clean hands, saying, hey, we're not here to trample on what you've already done or what you have decided. We are just here to act on the conscience of the party to make sure that the justice gets done.
Mm-hmm. Yeah, absolutely. Yeah, I would read that the same way. And I was looking for a little quote here because these two little paragraphs do here are really dispel a lot of the misconceptions that you see about what equity is out there on the internet. Because I hear this a lot, that like equity is judge-made law. If you're getting into chambers, then you're, it's judge.
Right. If you're in concurrent jurisdiction, equity is judge-made law because they can give you statutory or administrative relief as if you're getting equity.
Yeah.
But you're,
it's funny. The common law today is actually judge-made law, and that's why I think it's hilarious when people say that. I'm like, obviously, you just don't understand that term. Then I guess
it's like, whose common law is it? The common law of the people or the common law of the state? Because the common law of the state is usually a codified version of the organic common law, but bears the same name.
Mm-hmm. And I mean, they make that distinction. It's ever since the Erie case, that distinction has been made. Yeah. It's not common law.
Common law was abolished, right?
Yeah, exactly. That's the exact wording he uses.
Yep. Federal general law, common law is now abolished, and then they instituted a new federal general common law, but it was not the old one.
Not the old one. And that's where a lot of this misconception comes from, is because, it says the common law right there.
Well, I think, this is what they do is initially when they're trying to move you from one jurisdiction to the next, they will adopt all of your laws pretty much one for one and just let them run for a while. So people can't distinguish between the law they're getting on one side and the other because they're exactly the same. And then through a lot of these cases on the statutory side, they then use precedents to shift and change how that law is interpreted until eventually it's entirely completely different because it's
Mm-hmm.
been modified so much from the original one that it was mirroring off of.
Mm-hmm.
And yeah, so I think that's kind of just, I don't know, it's just interesting.
Yeah. Yeah, absolutely. Absolutely. Yeah. And that's something we'll get into in later episodes. I don't want to get too deep into the common law thing because that's not what we're talking about on
No, we won't.
this episode. But yeah, I did want to bring it up just because there's a lot of misconceptions on the internet today of what it actually is. So
Yeah, they throw common law around, but they don't know what they're reading, and they're not reading.
yeah, they're reading common law from the definition of 1776,
Yeah,
not post 1938. So
yeah.
yeah. So yeah, unless you got something else, I'm gonna go ahead and move on.
No, I think so. What's really interesting though is his use. I'm going to use the same word twice. His use of the word uses,
Yeah.
and it's just very interesting that what they're talking about there is beneficial use, beneficiary interests,
Mm-hmm.
and so with the introduction of beneficiary into the conveyances of the nation, um, so in that word conveyance too, they're talking about trust. So basically, what
Mm-hmm.
they're saying is and Bouvier even talks about or makes reference to the Sestake trust. So
Mm-hmm.
right there, referencing the Sestake trust, but using the word uses into the conveyances of the nation. And so they had to have a court of equity because of the presence of the Sestake.
Yeah, absolutely, and that's
So
just
I just
yep.
wanted to
Yep.
kind of draw that line so people don't get lost.
Yeah, yeah, perfect, love it. Love it. All right. So moving on to the next part of Tully's speech, states here the great difficulty in dealing with uses and with trusts led to the adoption of the writ of subpoena, ever since used by courts of equity. In the reign of Richard II, Waltham, Lord Keeper of the Great Seal, invented the writ of subpoena for bringing refractory trustees before the Court of Chancery. The writ was directed to the party not as common law writs to the sheriff or an officer of the court, but by acting on the conscience of the party, thus subjected to the court's jurisdiction, forced him to, quote, do justice by compelling the affirmance of right or enjoining the doing of a wrong, end quote.
I just got to add
Yeah.
something. That is a very, very important paragraph for people to understand.
Yeah, no, yeah, that rides right on the back of what we were just
Yes.
talking right
And
there.
I wanted to point out his very specific use of the word refractory trustees. A refractory trustee is somebody who is deflecting their responsibility as
Mm,
trustee. And so
mm.
that's why he's talking about the writ of subpoena, because you've got somebody who is supposed to be a trustee, either under the law or within their capacity, and they're either refusing to do it or obfuscating their duty. That's why the courts have this writ of subpoena to pull in a refractory trustees before the court of chancery.
Mm-hmm.
And it's also good to mention that refract, if you look up the definition, American Heritage Dictionary 1975, refract, to deflect, light, for example, break off, away, or backwards. So a refractory trustee is one that's backing away from the light, basically.
Yeah, if you're going into a chancery court, that's
Yeah.
exactly what that would be. Yep.
So the thing is, and that rides right along with equity, which is equity does not look to, um, basically they're trying to compel the duty of the defendant. That is what equity does. Is
Mm.
it looks to who is on trial and if that person has a responsibility to make sure that they do it.
Yep. Affirmance of a right or enjoining the doing of a wrong. Yep, that's exactly right. All right.
So
Yeah.
I just
Good.
thought that was important.
Yeah. No. Yeah. Great point for sure. Okay. The common law was utterly powerless to deal with the breaches of trust or direct the conduct of trustees or others occupying fiduciary positions. Whatever the form of action at common law might be, the remedy offered by its judgments was either 1. A recovery of the possession of land, 2. Recovery of the possession of chattels, or 3. The recovery of money, damages, or compensation. It is easily, therefore, to be seen how totally inadequate, particularly after introduction of quote-unquote uses, the law jurisdiction became, and how necessary it was that there should be tribunal that, by obtaining jurisdiction of the person, should have the power to compel the usee or trustee to perform his duties and restrain him in the violation thereof. The learned author Weingate finds the necessity for a jurisdiction that could act upon the conscience of the party in the inability of the common law, in many cases, to enforce its maxim, jus et fraus nuquam cohabitant. I didn't get the Latin for that one, but and in his Maxims of Reason, 1558, page 618, he says, quote, when truth is mixed with coven, that wicked herb, or coven with truth, the conjunction and mixture maketh all bitter and unsavory, and goodness is perverted into wickedness, for they cannot continue together, no more than fire and water, end quote. To disintegrate these and punish the result of the wicked union, or prevent an impending, threatened, or continued evil, it was necessary for the court to reach and act upon the person through his conscience under this maxim of Agere and Personam. In this too, quote, without direct interference with legal doctrines. Man, that's a great little section right there.
Yeah, when he said when truth is mixed with coven, I'm like, he's talking about commingling.
Yeah, that's exactly right, dude. That's what really got me going right there, because that's you know how we feel about commingling. You just can't do it, and he explains right here why. Or with truth, the conjunction and mixture maketh all bitter and unsavory.
Oh. And it's interesting too that he refers to one side as truth and the other as coven.
Yeah, isn't that hilarious?
Yeah. Yep. Which, him writing that in 1558 shows that not only do we have 500 years of jurisprudence on that point, but that in order for that point to be stated like that at 1558, you had to have at least 100 years or more of jurisprudence even before that for them to have come to that conclusion in that year. So people that don't understand equity, it's like, we have been operating under an equity jurisprudence for at least the last 1,000 years.
I mean, yeah. Yeah, that's a great point. I didn't even really put that together. 1558, he wrote those words.
Yeah, and the thing is because in order for someone to make a statement of wisdom, that what has to precede that is probably a considerable amount of time in several generations.
Time and study, absolutely.
Yeah. Time and study, and it has to be distilled and worked on, and kind of come to a consensus over the years. And so if he's all stating wisdom in 1558, it's like, well, he had to have been studying people that were 100 years older than him, worked 200 years older than him. And so it really does show that equity and the use of equity even precedes the formation of this country.
Oh yeah, by tons of time. Tons of time.
And surprise, boys and girls, when you trace it back, you find that equity is actually at the root of all things. So you can go back as far as you want.
Yep, that's absolutely right. And we talk about it all the time. That's why we're starting our podcast with this particular subject, because I think we were just talking about it before the show. If we start with this particular subject and show how these things have happened all over the time, we really think when we get into other subjects in later dates in the podcast, it's going to be an easier way for us to draw the line along.
Yes, because this truly is the dichotomy. Is between at law and equity. At least those are the what do you want to call the legalese terms for two sides of goodness, darkness, for truth, for coven. It really is the other side of the duality.
Yeah, absolutely. And as he just stated here, just one drop of the coven maketh all bitter and unsavory.
Yep.
So that's one code or statute in your stuff.
Yeah,
Maketh
that's
it
why
unbitter and unsavory. Make it bitter and
these
unsavory.
people, if they don't know how to correctly make a reference to a statute in their legal affidavits, they're going to get in trouble because
Yep.
if you use the statute as your authority, you are saying that that statute and whatever it's attached to, whatever authority it comes from, is your authority.
Mm-hmm.
And so that's why you can't reference it. Now, there are times in paperwork, if you are a private citizen, if you're going through that process, you will see it listed as like something along the lines of "in the spirit of," and then it will list a statute, because you're not quoting it as an authority, but you're saying, well, I'm acting kind of in the spirit of that without actually chaining myself to it.
Yeah, absolutely. And it's and there's a lot of things you do that with once you get into equity.
Yes,
So
absolutely.
Yep.
So I'm going to pick up here. All right. Among the early cases illustrating this maxim is the case of the Earl of Chesterfield versus Jansen, page 317, a bill for relief in a case of usury, where it is said, quote, such relief never prayed in any bill before. The pioneer case most frequently cited, see 1 Vernon, page 77, Archer versus Preston, is briefly referred to in 1 Equity Cases, page 133, where, in regard to land lying in Ireland, the writ of ne exeat regno was granted upon the defendant coming into England. So I wanted to talk about that real quick. So that Latin term, ne exeat regno, basically means that he shall not leave the jurisdiction. And it's a writ that was issued against someone. Basically, like it said, hey, you got a court date coming up. You're not allowed to leave the state. You're not allowed to leave the country. That was kind of their, it's like you're free to move around, but you cannot leave the jurisdiction. And so it's interesting here that the writ of ne exeat regno was granted upon the defendants coming into England with regard to land lying in Ireland. Now, people need to understand that in 1213, the Holy Alliance between the King of England and the Papal Authority was to grant all of the land of England and Ireland to the papacy for reasons that I guess we can all guess, trying to get into heaven, or there's some leverage going on there.
Yeah.
But that was 1213, and so they're talking about if there's a dispute of lands lying in Ireland, but the guy is in England, it's like, well, technically he has not left the jurisdiction, because Ireland is owned by England, which is owned by Rome. So technically it's all one jurisdiction. So they can adjudicate a case that is originating in Ireland with the guy in England, because it's all owned by the same guy, basically. So I just wanted to point that out there, that even though that's not what Tully is talking about in this speech, it just draws another line to papal having temporal authority and power over the realm that we're in.
Yeah, that's going to become more true every episode we get into this.
Yes. And so if you want further, look into the book Occupation Planet Earth, chapter 11, page 46. So it'll go into it further. But anyway, so he just cited that case there, and now we're going to be moving on. A very interesting case, probably the foundation of the equity jurisdiction, which compels stockholders or members of a society to enforce the individual liability for debts or obligations of the corporation or society by means of an assessment upon members, is found in the case entitled Dr. Salmon versus Hamborough Company, by the name of Governor, Assistants, and Fellowship of Merchants, Adventurers of England, and diverse particular members, etc. What a defendant! That's a huge defendant.
They could have just gone at all. But
the defendant company, the defendant company was incorporated by letters patent, with power to make bylaws and assess rates upon every member to defray expenses. It becoming indebted to the plaintiff in the sum of £2,000, he sought to be made good, averring that the defendant company refused to make an assessment or to exercise any power to ensure or promise payment. This is in 1671. On petition of appeal to Lords and Parliament, admitting that in ordinary course, the Chancery Court could not help the plaintiff. The House of Lords gave special directions to the Chancellor to examine as to the plaintiff's just debt and relieve as to such sum as the same shall appear to amount unto within 90 days of decree, and if not, that a quorum of said company shall, quote, make such leviations upon every member of said company as is to be contributory to the public charge, as shall be sufficient to satisfy the sum to be decreed the plaintiff in that cause, and to collect the money and pay over the same, with power to make new leviations, and if need be, supplementary leviations for that purpose. This case might be an instructive study to those who are or may become interested in questions as to the liability of trades unions and their members, and as to the remedy, if there is, against them for a breach of contract or for damages against them as a body or as individuals. So that was a mouthful, but
Yeah.
basically there was a doctor that was suing, I guess let's just call them a trade company. And the trade company, which was incorporated, so it was a corporation under letters patent, they have their own ability to make corporate laws and corporate policy. And part of that is they can those leviations, is talking about collecting dues or collecting basically taxes from the members of that corporation for the protection and liability in case of suit or to defray expenses. So they're basically like membership dues. And so the doctor was basically saying that, hey, this trade company, which has the ability to do that and has a debt to me, is not doing it. And so the Court of Chancery compelled the company to say, hey, you guys need to figure out how you are going to divvy up amongst yourselves to cough up the cash to pay this doctor. We'll let you figure out how you want to do it. And if further, taxes or whatever are required later on, then, you'll have to do that as well. And so that's what it's talking about, is how do we get individual members of a group or a society to be equally liable for a debt that company might owe another person. Mm-hmm. So that's when Chancery will come in, rip apart the corporate veil and say, hey, you clowns in here, you got to pay this guy, figure it out.
Yep, that's exactly right. Yeah, and that's a funny thing about this is these Chancery courts are when you get into these people that got billions and billions of dollars and stuff, that's the only way they go into court.
Yep.
I would imagine they're not going in anything at law, any of that. They know.
And what I will say that the reason that equity can do that is because equity is like light. If it shines, it's going to crawl into every little corner, regardless of how the room is shaped.
Yeah, and I'm sure we'll get into this on later episodes too. But I mean, that's literally where discovery came from, is the equity courts, just like the writ of subpoena.
Yep.
The whole practice of discovery came from equity, and that's what it is. That's what it. You're discovering. You're shining light on everything.
Yeah, it's like, hey, we need to look at some of the things that you guys might know because it's going to change the outcome of this case.
Mm-hmm. Mm-hmm.
And I will also say again, when the so how they decided that case with this doctor, this trade union, is they petitioned to the Lords in Parliament because technically it had to deal with a corporation, and so it was on the statutory side. And so they're like, well, Court of Equity can't exactly help, so that's why they gave them special directions. And it's like, hey, just do what you got to do. But that was in 1671, so again, 450 years of equity jurisprudence. In 1671, that was what, 118 years before the Constitution was written, where we have Article 3 saying that, the Supreme Court of the United States will be vested in one Supreme Court with the ability to hear cases in law and equity. Mm-hmm. It's like, well, right then and there, that is based off of at least 150 years of equity. And 1671 to now, that's 450 years of equity jurisprudence.
Mm-hmm. Mm-hmm. And it ain't gone anywhere. It ain't gone.
It's not.
No.
Because as goes equity, so goes the law.
Right. Yes, exactly. Equity follows the law. And we'll get into that one later. We'll get into that maxim later. I think that's all I want to say about this one. This little section here. So unless you got anything else, I'll move.
No, it just, interesting. They, the word "make such leviations upon every member of said company." They're talking about a levy, and a levy is a tax.
Yeah.
So, just that word, usually when they say levy, they're talking about a corporation or its members or anything else. So if you hear a tax being levied on the people, they're telling you how the people are viewed, and that is as a corporation because they're using a corporate taxing term.
Yeah. 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 That's true. That's true. Yeah, we'll get into that later too, for sure.
Yeah.
Yeah, nice. Good point. Good point. All right. So moving on here. Next paragraph, we got Cartwright versus Pettus, 1675, two Chancery cases, 214. Was a bill for an account of profits and a partition of land. The Lord Chancellor found the bill would lie as to the profits. Wait, was a bill for an account of profits and a partition of land. Okay, the Lord Chancellor found the bill would lie as to the profits, but the lands being in Ireland, no commission in partition could issue. A leading and important case in which attracted the most attention in the struggle of the Court of Equity to obtain a foothold for its jurisdiction to decide according to quote-unquote conscience by obtaining jurisdiction of the person was that of the Earl of Oxford case, 1 Chancery Reports. It was in this case that the dispute arose between Lord Chancellor Ellesmere and Lord Chief Justice Coke on the question of jurisdiction. The Chancellor contending that equity had the right to restrain persons who had obtained judgments at law for making such judgments instruments of injustice, not to overrule the judgment or attack its validity as such, but to prevent the party from using it contrary to conscience. Lord Coke considered this as an encroachment upon the powers and jurisdiction of the common law courts. The contention between these two became so warm and spirited that Lord Coke caused indictments to be preferred against the complainants and their solicitors. The Chancellor, Lord Ellesmere, sustained the equity jurisdiction, saying, quote, "There is no opposition to the judgment, nor will proof or justice of the judgment be examined. But yet the Chancellor may, where a judgment may have been obtained by oppression, wrong, or hard conscience, restrain the person in whose favor it was issued for proceedings under it." Okay, yeah. And a note. So basically, right there, what they're saying right there is that it's by acting on the person, they can actually reverse the judgment of the lower court, aren't they? Isn't that what they're saying there?
No, what they're basically saying is that, so Lord Coke was, you can think was like on the statutory at law side, and then Chancellor Ellesmere,
Coke did not like equity
side. And what they're saying is that equity is not going to oppose whatever judgment was issued. They're just going to make sure that the party that will issue the judgment doesn't abuse it. And basically, what my note was is like, you will not abuse your relief or judgment that was granted in your behavior. It's like, okay, you got what you wanted, but don't abuse it.
Right.
And Lord Coke was saying, well, you can't step in, or against the plaintiff to restrain them because you're infringing on my jurisdiction and I issued. He's like, well, I'm not going to get in the way of what you did. I'm just going to get in the way of what they might do now that they got what they wanted. And Lord Coke basically, I think, was saying, well, we'll just indict them if that happens. And the Chancellor was saying, well, I think, it's maybe we don't need to do that.
Yeah. Okay. That's making sense. And if the more you research Lord Coke, he did not like equity. He was not in favor of the equity jurisdiction at all.
No, neither did Oliver Wendell Holmes.
Nope. Nope. So much. Yeah, him and Mr. Brandeis. They're the ones who.
Louis
Oh,
Brandeis.
Louis Brandeis, Zionist president of the Zionist the labor union. Just
Yeah,
saying.
you want to? Yeah, Eric John Phelps. Every time I think I hear Louis Brandeis, I always hear an Eric John Phelps voice.
Yeah, that's hilarious. All right, I'll move on to this next section. Then we're about done with this little spot, and we'll have some time to chat after we get done with this. We got about 20 minutes to fill. Okay.
Great.
And in a noted case, sustaining the jurisdiction of equity, having jurisdiction of the person to grant the specific performance as to contracts regarding land in foreign countries, is that of Penn v. Lord Baltimore, 1 Vesey 444, wherein it was held that though the agreement could not be enforced by a proceeding in rem, which is on paper, yet that the strictly primary decree in a court of chancery should be in personam, and the defendants being in England, it could be enforced by a process of contempt in personam and by sequestration. A court of equity adopted this plan of acting upon the conscience of the defendant for the purpose of bringing him within its jurisdiction, and having done so, it proceeds to create equitable rights, equitable estates, and interests, unrecognized and unknown to the courts of common law. And in the protection thereof, its jurisdiction became necessarily greatly extended. Regarding the equitable estate or interest as the real ownership, it soon proceeded to act in rem when necessary to do. Acting in personam was merely an entertaining wedge by the means of which it obtained a foothold into the administration of justice upon the principles founded in equity and good conscience. That's pretty interesting.
What I wanted to say was when he goes into a court of equity adopted this plan of acting upon the conscience of the defendant for the purpose of bringing him within its jurisdiction. Having done so, it proceeded to create equitable rights, equitable states, and interests. Right there, he's talking about subrogation, because it's like, look, we're going to have control over your person. And if the person says, well, I'm not a volunteer surety, I'm not volunteering to be trustee for this name or fiduciary, I don't want this. Because of that, under the laws of subrogation, they now have an equitable rights, equitable estates, and interests. So, basically, if someone gets brought in as a defendant into a jurisdiction, and they are not the secondarily liable, or they're not the surety, fiduciary, or they're not the trustee, the court of equity will recognize their ability to invoke the right to be subrogated to the moving party, depending on their status. If they have a higher claim over what it is that's being disputed, or they can prove that their status shows that they're not the secondarily liable, or maybe they're even the beneficiary. If they get pulled into that jurisdiction, they now have equitable rights and interests, like reimbursement. If they're forced to pay under compelled performance and they didn't need to be, they can put in for a bill for reimbursement and show that, hey, I was not secondarily liable, but I had paid the bill. Now I'm going to step into the shoes and force performance so that I can be reimbursed. So it's just interesting right there. That's just an interesting way that they're referring to subrogation, and that they're absolutely recognizing it.
Yeah, and I like that he also states that it's unrecognized and unknown to the courts of common law.
Yep. Not cognizable by this court, boy.
That's exactly right. Yeah, and then that's what was it? There's the California Supreme Court case that the common law is sufficient to cover everything now besides trusts.
Yeah.
And this gets really to the heart of that, and subrogation is at the heart of that whole thing too, because
that's
you can't.
Crazy.
Yeah.
Common law, or the common law that they created and wrote, basically can touch every single corner except
Except
trust.
trust.
Yeah.
You know?
We have control over everything except trust.
Which they can't get control over. That's the thing. That's why equity is so important, because this is, in my opinion, this is the one thing they can't kill.
No.
They can try and kill everything else on the planet, but
This was my biggest note. The very last sentence in here. I think we may have touched on this earlier, where acting in personam was merely an entering wedge by the means of which it obtained a foothold in the administration of justice. And so that's what they're talking about, is they have to have an in somewhere into the law in order to make sure that justice is actually done. And so that's why they act on the person. But the thing about it is, like, military, these are my notes. Military concurrent jurisdiction basically uses the principle or the equity, or this equity maxim, to gain in personam jurisdiction, and then it proceeds in rem or at law.
yeah.
So in order to bring you into the at law side. But by invoking the equity maxim and operating equity as the first move, you also have recourse to invoke equity, namely subrogation, exoneration, reimbursement, substitution, or stipulation. And this just drives home the point that they always start with equity because they need your consent to waive your turn to do equity.
Exactly. What's the first question they ask you when you get into court? What's your name?
What's your name?
Yep.
Tell us who you are if you're not who we're looking for.
Yep.
And that's the trick, is that the relationship between you and another human being always has to start with equity.
Yeah.
It's like they come to you, they do equity, or they ask a question or they request something, and they have to leave it open to you to respond in kind.
Exactly.
And this is how the military will do that. And we're talking, military jurisdiction, martial
law government. Yeah. Martial law. Yeah. Just because there's not tanks in the street doesn't mean we're not under martial law.
Nope. And the very crux of all this is they're not going to take any of your rights away. There's no fraud here. They're not breaking the law.
No fraud here.
They, under the laws of God, the immutable laws of creation, you have to be the one to waive it. And that's what they're trying to get you to do, is waive your consent, or waive jurisdiction, or waive your rights. And you do that every time you sign with an unrestricted signature, or you start quoting statutes, or just rambling off a bunch of patriot
mythology nonsense.
Sorry, ma'am, that's patriot mythology nonsense. You're going to have to unlearn that.
You're thinking like the masses, ma'am.
Yeah. So, yeah, I just wanted to put that out there, is that all these people are like, they're breaking the law and they're taking my rights away. They are not.
No, they're not. There's no fraud here. We will say that over and over and over again. There is no fraud here. You are playing in their sandbox.
For lack of knowledge.
Yes, exactly. The slaves could not read or write.
Yes,
that's exactly
and
right.
That's another thing that I see. Well, I guess, are we done talking about in personam, and we want to start connecting it?
Yeah, we can move on a little bit. Yeah, we got about 13 minutes to fill. So yeah, if you want to jump into something else, we can.
Okay.
Yep.
Well, I had another.
No, I did want to. Since you brought up waiver and consent, though, what is it? Section 39 out of the Trading with the Enemy Act, where that's.
What's that one?
Well, I'm pretty sure that's where they talk about the remedy of how you get your stuff back.
3.9. I mean, there you go. It's right there.
Right, but yeah, that's the section where they talk about remedy, and it's what that section is titled, waiver and consent.
Yep.
So, yep. Oh, yeah.
It's it even, because people don't, a lot of times when they think they don't expand their scope out far enough, they think up to and including the U.S. Constitution, and they stop there.
Exactly.
They can do, which is ironic, because in the Constitution it says that any treaty signed are the law of the land. So, when we signed the Hague Treaty, or the treaty with the UN when we became a part of the UN, I've got an encyclopedia from 1985 that talks about the treaty with the UN, and basically it says that the United States will adhere to and carry out the directives of the UN Security Council to the best of its ability, or something along those lines.
And that's,
And
I'm sure
so
that's binding too, right? It's got to be.
it is, because
Yeah.
the United States, yeah, they're so the United Nations is basically the law of the land. The Hague Treaty is the law of the land. It's just groups of rules within rules within rules, and depending on your status, where you're operating, and what you're quoting, depends on how it is that you quote and look at those things.
Mm-hmm. Yeah,
So
absolutely. Yeah, yeah, that's a fundamental thing to and understand too, because even a lot of people in this law space probably have never even heard of the Hague Convention.
no, I
And there's two events in history that play a huge role in what we're dealing with right now.
no. Yeah, I mean, the Hague Conventions of 1899 and 1907, I
Mm-hmm.
think, are just as important as understanding Trading with the Enemy Act as amended by the Emergency Banking Relief Act.
Mm-hmm. Yeah, and
Because,
I think it's important to understand this kind of stuff in a chronological order too.
yeah,
You know.
absolutely. Because, understanding cause and effect, I think, is very natural for a human being. And you can't understand the effect unless you go back and look at that cause. And you can't understand that cause without seeing what had affected it. And,
Mm-hmm.
eventually you find yourself back in the 1500s, Mr. Hugo Grotius writing international law. And then that international law, which recognizes equity and
Yep.
nationals, was
Absolutely.
memorialized by The Hague in 1899. They memorialized both him and his work. And then in 1907, 8 years later, they Article 23, that the rights of nationals are not to be suspended or abolished.
Mm-hmm. Which is why we say private American national.
Private American national under the Hague Convention of 1907,
Mm.
Article 23,
Mm-hmm.
defining the difference between belligerents and nationals. And that's what it is. It's waiver and consent. It's
Yep.
belligerents and nationals.
Yep.
It's public and private.
Yep. Yep. There's only two things going on. There's no, all the other stuff is gone. There used to be three different court systems in the court. There used to be different rules for. There used to be an actual Admiralty Maritime rule book for the federal court systems, equity rules, common law rules, all of that stuff. And but
Yep.
that's all gone now. That's all gone. So now we are dealing with only two realms: exclusive equity and martial law.
It's like they took a house that had, like 100 different doors on it, and they pasted over 98 of them, but they still have to leave two of them open.
Yeah, you got to get in and out.
Yeah.
You
And
know?
so a lot of people were like, well, they've been consolidating and merging all of these jurisdictions. It's like, right, but it doesn't mean that the remedies inside those individual jurisdictions aren't still available. You just really have to know the language, and not be putting your feet in multiple trying to get something done.
Yeah, absolutely. Yeah, that's I the more I look into this, kind of the more I appreciate it.
Yeah.
It is
Easier.
right. It's instead of having three different court systems that we got to learn all the rules to, and to, should I go into this court? Is it this kind of
Yep.
court? Is it this? And that's all that's gone. It's either martial law or exclusive equity.
Yep.
There is no other
And
in between.
so like here in Idaho, I was doing some research, and basically I think it's Article 5 is Idaho's judiciary. It's pretty much almost word for word of the 1873 Judicature Act,
Mm.
where I think that was kind of the birth of the concurrent jurisdiction,
Yeah.
um, or at least the outward expression of it, which
Mm-hmm.
is where they're sitting in both the civil side and the equity side at the same time, or the outlaw side and the equity side at the same time. Because in the Judicature Act, it basically says, the distinctions. Correct me if I'm wrong. It might not be the Judicature Act, but anyway, the reference made is that the distinctions between law and equity are hereby abolished. And then what follows is some language but the judiciary will still protect private wrongs or private rights, or redress and things like that on a private side. And I've
Mm-hmm.
seen several state constitutions that were not part of the original 13 colonies. A vast majority of them are concurrent jurisdictions because they don't have a history of equity jurisprudence. So they just have one door, and they say, if you want equity, you just come in the door, you got to know what you want, and you got to speak the language.
Mm-hmm. Absolutely. Yeah.
And so Idaho's the same way, where it was a federal territory before it was a state. And which is interesting because when they wrote the Constitution, They basically said that they're an inseparable part of the Union. They had a Declaration of Independence and became a full-fledged state, and then adopted the U.S. Constitution and adopted a lot of the language out of the 1873 Judicature Act, which also says, even though it's a concurrent jurisdiction, it says that when there is conflict between the rules of the common law and equity, the rules of equity will prevail.
Mm-hmm. Mm-hmm.
So if people are like, well, it's concurrent jurisdiction, I don't know which one I'm in. It's like, if you just keep speaking the equity language, that's all you got to do.
And they're never going to say, good job, buddy. You did it.
No, they're not.
They're never going to say it. Even in these Supreme Court cases that I have for us to talk about later. Unless you know the equity language, they're not saying that, well, actually, in the property case, what is it, the Massey case, Massey v. Watts, they actually do explicitly state it in there, which that's the first time I've ever seen it. But 9 times out of 10, they're just going to be throwing, like in an exclusive equity case, you don't plea your case, you pray it. And it's going to be those little things in these cases that you're going to be reading, and that's how you're going to know if this is an exclusive equity case or not. They're not going to, 9 times out of 10, they're not going to tell you. This is it's a very kind of ephemeral thing, and but the good thing about that is that the rigidity is gone, and you only have to learn some principles. You don't have to learn 60 million codes and statutes. It's just some principles, and some principles that you can just live your life by anyway. So why not learn them?
Yeah, no, 100%. I agree. Silence is the best answer you'll ever get. Like if you're having a discussion with somebody and you say something and they just put their hand up, they look away and they walk away. Right then and there, they don't have to tell you that you won.
Right. So, you know everything you need to know, and nobody had to say a word.
And I did make a note because, where was he? Such relief never prayed in any bill before. The Pioneer case that was most frequently cited, we talked about earlier.
He said it in there. Yep.
Yeah, you didn't. It wasn't an action or a petition. It was a prayer, because again, it's connected with the lofty moral Christian principles, which is the root of equity.
Mm-hmm.
But Bouvier, when he says prayer, he defines it as an element of chancery pleadings. It's that part of a bill which asks for relief. The skill of the solicitor or the lawyer is to be exercised in framing this part of the bill. An accurate specification of the matters to be decreed in complicated cases requires great discernment and experience. So they're using biblical language right then and there when you're trying to have your case heard.
Yeah, absolutely. You're not pleading with anyone, you're praying. That's that when I found that out, because I just was reading a Supreme Court case when I figured that out. As I was reading a case, and I'm like, what are they talking about praying? What are they talking about? I've never heard that term before. And I'm like, oh, so many things clicked together. I was like, that you don't plea in equity, you pray in equity. Duh.
Yeah. Well, it's like if there's a home intruder or something, or someone takes you hostage, you're going to be pleading with them. But you're going to be praying to God.
Yeah, absolutely. And that's the big distinction is that judge, when you're an enemy belligerent, you're pleading to him. Please, don't take my stuff.
They're judge, jury, and executioner.
Absolutely.
And when you plead, you're basically like on your hands and your knees going, oh, please, 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 please don't hurt me. And he's like, all right, well, I just won't hurt you as much. Yeah. But, I still got a job to do. I got to protect this property for the commander-in-chief up there, buddy. So. Yeah. So that's why, when you pray, you're not going to pray to the executioner. You're going to pray to God.
Exactly. So, I love it. All right, man. That wraps up hour 1 for us. Unless you got anything you want to add, we'll.
No, not without going off the rails. So.
Yeah, we start getting too much into it, we'll go a whole nother hour here on something completely off topic. So let's rein it in. Let's take a little break before we get back to the next hour, where Whitestone's got some stuff he's going to bring up for in personam jurisdiction. I got a couple of Supreme Court cases we're going to talk about, and we're going to continue the subject on in personam, the first fundamental maxim of equity jurisprudence. So I hope you join us on the other side.
thing here is that everyone's word should be meant for a use.
And the words that I'm using today are meant to pull down idols within people's temples.
Meaning that I want to destroy
Falsities that they have idolized.
for their entire life.
And just pull those out and sweep them clean. And before that temple,
And get reinfested with a new lie. Give it true life.